I am today continuing my lecture on important features of CPC. I think I have come up to section 87 and I started section 88 dealing with interpleader suit. I have to explain what interpleader suit is. Of course, I touched on the subject last time, but I could not complete it because of paucity of time. Therefore, I will start that section once over again for the purpose of explaining to you the intricacies of that section 88, interpleader suit. What is that interpleader suit? Interpleader suit is nothing but a suit filed for the purpose of according relief to any one of the defendants. In the interpleader suit, plaintiff has no interest at all in the stake involved in the case. He has to just brought to the knowledge of the court as to who is the real claimant for the property or for a debt or for money that is with him, but he is under a confusion to whom it should be payable or to whom it should be delivered. This is the only doubt for which now he approaches the court. He may be indebted to another person, or he may be liable to deliver a property to the rightful person. In such circumstances, he will file a suit saying that I am owing this much amount to one of the defendants, but there are various claimants now coming forward to claim this property or the money. Therefore, kindly ascertain who is that person among the defendants who is eligible to get that amount or the property. This is the suit. In that suit, he has no stake at all, except for the costs and also the expenses he incurred for the purpose of prosecuting that suit. Only cost for the preservation of the property which he is having or which he is having custody of. Therefore, only for the cost and also the expenses he has incurred for approaching the court. Once that cost is paid and also the expenses for the custody all met, all given to the plaintiff, he will walk out of the scene. The court itself will dismiss him from the suit. Then the dispute is between the defendants. Among the defendants, one will become the plaintiff. Not in the sense he will become a formal plaintiff. No. One will be treated as a plaintiff and other will be treated as a defendant. Therefore, the plaintiff and the defendant are already there as defendants in the suit, but plaintiff has no stake at all. Then among the defendants, anyone has to establish. Once the court comes to the conclusion that only one, say for example, defendant one is eligible for this for delivery of possession or for the money deposited in the court by the plaintiff, then he will alone get that relief. That defendant will alone get the relief. He is the right person. Now, there are certain other important conditions also. Suppose a suit is filed by the plaintiff and the defendant say, no, say for example, he says, I am having 1 lakh rupees, but to whom it is payable, it has to be ascertained. Therefore, he filed the suit. But the defendants or any one of the defendants says in the defense, no, the plaintiff is owing more money than this 1 lakh rupees. Therefore, he has to pay rupees 1 lakh plus that extra amount which he claims. In such of those cases, the court will not enter into that dispute. The court will only direct him to pay that 1 lakh rupees, and the 1 lakh rupees alone, the suit will be continued. And regarding the rest of the amount which any one of the defendants claim as payable from the plaintiff, the court will direct him to file a suit. Or any person who is entitled to claim that 1 lakh of rupees paid or deposited by the plaintiff will be permitted or will be directed to approach a court of law. He has to file a separate suit against the plaintiff for the remaining sum. But he cannot stake claim to that extra sum of money which he claimed over and above that 1 lakh of rupees. Therefore, only the amount admitted by the plaintiff alone will be the subject matter of the suit, or only the liability admitted by the defendant will alone can become the subject matter of the suit. Beyond that, the court will not enter into any issue with the plaintiff. For that, the defendant has to, or the rightful defendant who is held entitled to that amount deposited or delivered by the plaintiff, will be permitted to file another separate suit. And if any, in case any suit is already pending with the court, where matter is the subject matter, is the same subject matter, which the plaintiff wants to approach the court for payment or for delivery to a rightful person, is already the subject matter in another suit, and in that suit, a comprehensive decree can be obtained, including the relief which the plaintiff wants to raise in the interpleader suit. If can be disposed of by the earlier suit, the court will not permit the plaintiff to file the interpleader suit. If there is already a suit pending, by having the subject matter in the earlier suit also, and the court feels that in such a suit, the request of the plaintiff can also be disposed of in the earlier suit, then the second suit, that is the interpleader suit, will not be allowed to be filed. Therefore, only when the plaintiff has no other option or no other remedy, the court will permit you to file this petition. And the case law on this subject is dealt with in a case rendered in 2003, 2 CTC, page 75. That case deals with a case wherein the defendant raises another dispute. If another dispute in the sense, the plaintiff is liable to pay more, or the plaintiff is liable to deliver more property, in those cases, court will raise an issue only with regard to the admitted portion and pass a decree only with regard to the admitted portion. That is reported in the case which I have now cited. And another case law is the court has no jurisdiction at all to travel beyond what the plaintiff has admitted, what the subject matter the plaintiff has admitted. Therefore, it involves the question of jurisdiction. Therefore, in an interpleader suit, no question without reference to the admitted fact cannot be raised. Therefore, even when, suppose even in a case where the defendant now stakes a claim more than what the plaintiff has admitted. Suppose if the court, even if feels that the plaintiff is liable to pay more, or the plaintiff is liable to deliver more property than what is admitted, even the court comes to the conclusion on the basis of facts, the court will not enter into that issue at all. Cannot. The court has no jurisdiction. Now that is decided in 2003 MLJ 428. If you go through that decision, you will understand. The court has absolved its responsibility or absolved its jurisdiction from dealing with those portion that comes beyond the admitted case of the plaintiff. The court has no jurisdiction at all. And next is, you have to read this section 88 along with order 35 rule 5. Order 35 rule 5 gives more points or more an elaborate view of what section 88 is. You can understand section 88 if you read along with order 35 rule 5, where an illustration is given. That illustration I have already given in the last class. A jewelry is deposited with one particular person, and another person claims that the person who deposited has already received money for this jewelry, and it claims that that jewelry from the person in whose custody is entrusted by the person. But here, that person who is holding the jewelry as an agent of the original owner cannot file a suit saying that there is a dispute between the other person and the original owner. It cannot be said because he is holding the jewelry as an agent. But on the contrary, if the person who deposits the jewelry in another person and he gets money from a third party saying that you treat the jewelry already deposited with the with another person, you take it as a security. In those cases, if a dispute arose between the person who has advanced money to the owner of the jewel and also the person who is having custody of the jewel, then the person who is having the custody of the jewels can approach the court to decide who is the rightful owner of the jewelry. In those cases, interpleader suit will arise. And as I already said, in an interpleader suit, the dispute is only between the defendants, not between the defendants and the plaintiff. And the defendant will plead against each other. They will interplead with each other, the defendants, not as against the plaintiff. Therefore, it is called interpleader suit. Interpleader means the defendants will amongst themselves plead one against the other. And we'll come to section 89. 89 is the power conferred on a civil court to refer a dispute for disposal to any other outside agency. It is not as I say, in modern times, everybody feels, even the legislators and all parliamentarians feel that the civil court or the courts for that matter is not the only forum where we can resolve disputes. The resolution of this dispute can be done by outside agencies also, but they will also exercise the same power as if it is a civil court. But this device has been invented only for the purpose of reducing the workload of the court. Already the courts are overloaded or overburdened with the arrears of cases pending for years together. Therefore, the power that we decided or took a decision that the court should be relieved of cases which can be decided by outside agencies also, so that all such cases can be taken out of the file of the court and entrusted to some other agency for the purpose of disposal of case. Therefore, with that aim in mind, the section 89 of the Civil Procedure Code has been enacted or incorporated. What are those outside agencies? The outside agencies are, if the court feels that there is an element of settlement during the course of the proceeding, if the court comes to the conclusion or gathers an idea that this is a matter, instead of dealing with as a disputed case or as a between a rival suit, then or adversarial case, it can refer it to the third party. But court must come to the conclusion that there is some element of settlement. And if the opinion of the court should be shared with the parties. And the party should also agree for such a settlement. Or they must agree with the idea of the court that it is a fit case for settlement. Therefore, the court must take the parties also into confidence. In such a case, the court should settle this point of dispute. What are the points of dispute? And this point of dispute should be once over again given to the parties. And the parties, if they are agreeable, then it will reframe those questions and send it to what are the other agencies. Send it for arbitration. And it can also send it for conciliation. It can also send it for judicial settlement, including settlement through Lok Adalat. Now, Lok Adalat is also has come into existence, Lok Adalat. And also mediation. Mediation also now in all the courts, now a mediation center has been open, where the courts will immediately, if there is an element of settlement, if there is any possibility of settlement, they immediately send it to mediation centers attached to each and every court in Tamil Nadu, in other parts of the country also. Even in high courts, there is a mediation center. In city civil court also, Madras, there is a mediation center. But in all those instances, the cases are not decided. The cases are dealt with between the parties with one proceeding officer, and the proceeding officer trying to bring about a settlement between the parties by urging both the parties the profitability or the advisability of coming together for a settlement. If the parties agree, that will be recorded, and this record of that proceedings will be sent back to the court with their report. And if the court agrees, then the court will affix its stamp of approval and passes a decree on the basis of the report. This is the procedure for mediation. Now, what about the reference to arbitration? The court can also send a case for arbitration. When arbitration is referred to, or it is referred to arbitration, the Arbitration and Conciliation Act 1996 will apply. The provisions in that act will apply for the proceedings of the arbitration. And the conciliation also will be taken care of by the provisions of Arbitration and Conciliation Act 1996. What about a judicial settlement? Judicial settlement means the court will refer to Lok Adalat under section 21. 21 of the, you kindly take a note, Legal Services Authority Act 1987. Legal Services Authority Act 1987. Therefore, the court will refer to Lok Adalat under section 21 of that particular act. Once that case is referred to Lok Adalat under that section, all the provisions of that particular act will get attracted. Therefore, it will be proceeded as if it is a case taken by the Lok Adalat. Therefore, the procedure given under Lok Adalat will be taken advantage of by the person who is proceeding over that Lok Adalat. And also, one more point is including settlement through Lok Adalat. Here also, Lok Adalat doesn't mean the Lok Adalat established under the Lok Adalat Act alone. The court will also form a Lok Adalat. In that Lok Adalat also, this dispute can be dealt with by the person who proceed over the Lok Adalat. And in such circumstances also, that report will be sent to the court, and the court will affix its seal of approval. And in both the cases, whether it is referred to under section 21 of the Lok Adalat Act or directly to the Lok Adalat, in both the cases or in both the instances, the Lok Adalat Act will be in force or will be utilized for the purpose of bringing about a settlement between the parties, will be binding on both the parties. And here, for judicial settlement also, there is one more provision in that particular section. Judicial settlement. Judicial settlement is nothing but a reference to some persons or some organization who are dealing with conciliation or dealing with mediation of cases between the parties. They are well known in a city or in a metropolitan town. They are well known. There are certain centers which are interested in disposal of cases between the parties. If they have gained a reputation, the court will also take judicial notice and will send it to them. But these cases can be referred to that institution only in metropolitan cities where there are well-known advocates or well-known persons trained in law. But it may not be applicable in rural areas where we cannot expect such facilities. Therefore, judicial settlement can be resorted to preferably only in metropolitan cities or in cities where such facilities are available. Even good lawyers are available only in metropolitan cities and also some cities. Therefore, it may not be universally applicable in all the places in India and also in Tamil Nadu. Therefore, this judicial settlement is resorted to only in limited places. Even in Madras, there are institutions which are interested in disposal of cases or bringing about settlement between the parties, and they are well known, to which mediation centers or any center they are called, it will be said. There is also one mode. Now, what are the conditions for referring the dispute to those institutions or by those methods? The preliminary condition is existence of element of settlement. The court must feel, as I already said, you read section 89. First of all, the first condition is that there must be, in the opinion of the court, an element of settlement. Then the party must agree with the idea of the court, idea formed by the court about the possibility of settlement out of court. then the court will formulate the terms of settlement in the court itself. That terms of settlement will be circulated to the party. And after the perusal of the terms by the parties, the parties will be called upon to express their observation on the terms of settlement. If they fully agree by writing, then the court will reformulate the terms in accordance with the observation, and then it will be put to mediation or any settlement out of court. Therefore, these are all what is required as far as this settlement outside court is concerned. And also, in some cases, there may be several issues involved in the disposal of a case, or in a suit. Several issues may be raised, but the court will see whether all the issues could be settled out of court. If the court feels that all the issues cannot be settled because of the difference of opinion between the parties, it will segregate such of those issues as in the opinion of the court that can be decided by an agency outside the court. Therefore, keeping the issues about which no settlement is possible to be decided by the court, the rest of the issues on which it is possible for settlement, it will be sent to the outside agencies. Therefore, it can be segregated also. The issues that can be segregated will be separated and sent to the outside agency for disposal. Therefore, it is also possible. And in case of arbitration, one more suggestion has been given by court in number of cases. Of course, the court can direct the parties to go for arbitration. In case they the court directs the parties to go for arbitration. It is necessary, it is not necessary, it is advisable that the court should immediately nominate a person as the presiding officer of that arbitration. Or arbitrator should be named in the very order itself, so that the parties need not waste time by picking up an arbitrator, but it may even consume time. Therefore, in order to avoid it, and also a future difference of opinion between the parties, it is better the court itself nominates a person as an arbitrator and send it for arbitration. This will be the right course according to the opinion of our courts while dealing with cases. Therefore, this is all about section 89. Then one more settlement is, or one more power that is exercised by the civil court regarding opinion, section 90. In section 90 gives a power to the court to express opinion of a case brought before it by the party. Here the parties by agreement bring a case before the court for its opinion, and also with an undertaking that once an opinion or an order is passed by the civil court, then that will be binding upon them. Suppose there are persons who may have a long-standing dispute between them, but they may not be able to find a solution to that problem. But they will put all those problems in an agreement, and that agreement they will say, now we will appoint we will approach a court of law, and in that court of law we present this agreement, and the court will decide as to who is eligible and what are the solution that can be found out. If such a solution is found out in a court of law, there must be a clause in the agreement that any opinion rendered by the court while seeking opinion is binding on themselves. That is the only condition. Therefore, in case court finds that a particular person is entitled to, or the other person is entitled, then the party should agree, and also it should be there in the agreement itself. Therefore, the court can render an opinion on a matter which is brought before it as per an agreement between the parties. That is spoken of in section 90. And the next section is section 91, dealing with public nuisance. In public nuisance also, a suit can be filed, but in public nuisance cases, the plaintiff need not be a person who is interested in that public cause. Personally, he may not be interested in that public cause personally. He may be affected or he may not be affected. But for the purpose of improving the welfare or protecting the welfare of the public for a public cause, he can always file a suit. Here the suit cannot, he cannot directly file the suit. One or two conditions are there. It can be brought to the knowledge of the Advocate General in Tamil Nadu, and also in the district collector if he is already appointed by the state court. Or two persons can approach the civil court and file a suit. But before filing the suit, it should be accompanied by an application for permission. Therefore, permission has to be accorded by the civil court before entertaining the suit. Therefore, in cases of public nuisance, or public nuisance means any damage caused to the public, any or public installations, public property. In those cases, the court will entertain cases filed by two persons and more, provided they must get the permission of the court to proceed with that case. The court has to accord its permission to file the suit. Therefore, these are a must. Either Advocate General himself can file the suit if such a cause is brought to his knowledge, or barring that, any private individuals also can file the suit, but they must be more than two or more. And also one more condition, they must obtain permission from the court. Once permission is obtained from the court, then they can proceed with the case. And the court will render its judgment. But once the judgment is given, then the public cause ventilated by these two plaintiffs or more will be binding on all those persons who are enjoying that facility or who are interested in that particular public cause. Therefore, this res judicata will be affected. I have stated in the subject dealing with res judicata under section 11. Therefore, it is a case decided on merit. Though it is filed, the case is filed by two persons and more, not all the persons in that community or in that area. It will be binding on all the persons who are the beneficiary of that public cause. Therefore, it is binding, and also res judicata will principle will apply to the cases decided in such of those cases in the public nuisance. Then public charities is spoken of in section 92. This public charity case also can be filed either by Advocate General or two and more persons approaching the court with the permission of the court. And what are the criteria to approach the court regarding public charities? Suppose if there is a public trust dealing with charity and also some religious purpose, and the interference of the court is necessary for certain purposes, which I will enumerate a moment later. But here, if the public, there is a breach of trust, and also interference of the court is absolutely necessary for its proper administration, then always two persons or more can approach the court with the permission of the court and file a suit. What are those reliefs that can be sought? But I will read the section for your recapitulation. In the case of any alleged breach of any express or constructive trust created for public purposes, but section 92 deals with only public trust, not private trust constituted by private person. But if any person created a trust for public purpose, then it will be dealt with only by section 92, not any other provision of law. Section 92 deals only with the public trust. But here, the provision that the trust, not the trust or the subject matter, the charities, and also other benevolent purposes, which are the subject matter of this Religious Endowment Act, Tamil Nadu Religious Endowment Act 1956, I think. Therefore, those charities will not come under section 92. That will be dealt with by the particular act only. Therefore, in cases where the public purposes are covered by Religious and Endowment Act 1956, then that will be dealt with only by that act. It will not come under the purview of section 92. But section 92 deals with purely public purposes. And I will read it. If in case of any alleged breach of any express or constructive trust created for public purposes of a charitable or religious nature, or where the direction of the court is deemed necessary for the administration of any such trust, the Advocate General or two or more persons having an interest in the trust and having obtained the leave of court may institute a suit in the principal civil court of original jurisdiction. But in district, it is a district court. And in Madras, either the High Court or the principal civil court of the original jurisdiction of any other court empowered in that behalf by the state government to obtain a decree. That what are the relief one can ask for? Are there two persons interested in public ask for is now enumerated in section 92 itself. Removing a trustee and also appointing a new trustee, vesting any property in a trustee, or directing a trustee who has been removed or a person who has ceased to be a trustee to deliver possession of any trust property in his possession to persons entitled to possession of such property. Therefore, if the court declares a particular person not entitled to hold the post of a trustee in that particular trust and he is removed, then there will be a direction also given by the court, directing him to deliver possession of any property which he has handled so far or which he has in custody of that particular property belonging to the trust, to deliver it to the rightful trustee. And directing accounts and also inquiries relating to. It will also cause an inquiry with regard to the handling of its funds, trust funds, and declaring what proportion of trust property or the interest therein shall be allocated to particular object of a trust. Therefore, there may be a fund or there may be properties, and these are all dedicated for public cause. In such those cases, the court will also direct how much funds or how much of the property that can be allocated for furthering the cause of another public cause. Therefore, the court has the power, ultimate power or ultimate discretion to allocate funds and also the property for the purpose of furthering a cause, a public cause, or public charity. This court's jurisdiction, absolute discretion of the court, and also authorizing the whole or any part of the trust property to be let, sold, mortgaged, or exchanged. Then one particular restriction or prohibition found in section 92 is that it cannot be sold. The property belonging to the trust cannot be sold, mortgaged, or let or otherwise any encumbrance made. No encumbrance can be made on the property of the trust unless the court feels that it is absolutely necessary for the advancement of the purpose of the trust. If the court feels that it will advance the cause of the trust, public trust, then alone it can permit a property of the trust to be sold, mortgaged, or otherwise encumbered. Therefore, without the permission of the court, any property, if encumbered, will be absolutely void. And settling a scheme. The court can also settle a scheme. Scheme means for the administration of the trust, a scheme can be framed always by the court. Then the trust will be conducted or the trust will be governed, administered only in accordance with the trust framed by the court. Therefore, the court has absolute power in respect of public trust, the framing of a scheme. The scheme can be framed and granting such other relief as the court may feel fit and proper. Then the next point is whether the purpose for which the trust has been created by the founder can be altered. It can be altered when the first basic principle is once a founder has started a trust for a public cause, he might have given in that instrument, creating the trust, the purpose for which the trust is created, and also how the funds of the trust can be utilized for public cause. There are all directions. These directions contained in the instrument has to be strictly followed. This is the natural understanding of any trust, because after all, he has dedicated his property for public cause. In those cases, whatever his wish for furthering the cause of the trust or for advancing the cause of the public, then it has to be respected. We are respecting his sentiment. But there are cases when the purpose cannot be carried out, or under certain circumstances, we cannot follow the directions contained in the trust deed. In those cases, and in the event of a public trust which cannot be administered in accordance with the wish of the founder, then one can approach the court saying that kindly alter the purpose. In those cases, the court will alter the purpose. For purpose means already the property has been dedicated for a public cause. But he may say for Tannir Pandal and also the scholarship given to the poor. Likewise, many public causes might have been cited. But sometimes if it is found impossible, practically inconvenient, then the court will understanding the difficulties that is encountered in the administration of the trust, court will alter the purpose slightly. But as long, but without prejudice to the sentiment of the founder, or as long as it is close to the spirit of the trust, it will not go far away or diverged from the main spirit of the trust. Therefore, without prejudice, causing much prejudice to the original purpose of the trust, the court can always alter the purpose of the act, the purpose of the trust deed. And also, suppose this is called Cyprus doctrine. Cyprus doctrine is nothing but a principle that will allow the courts to alter the purpose of the deed, because it is a deviation when the purpose of the public trust cannot be carried out as expressed or as directed in the trustee deed. The court has to necessarily find out a way. Therefore, the court will find out a way that is according to the Cyprus doctrine. It will alter it so as to suit almost the spirit, the very spirit of the trust. It will not very large or very widely deviate from the main purpose, Cyprus doctrine. And when this by Cyprus doctrine will come into play, that is section 92(3), where original purposes of the trust in whole or in part have been fulfilled. Suppose if the original purpose has been fulfilled, but the property stands and also the fund is in the bank, it has been multiplied, but purpose is over as per the trust deed. In those cases, the court will find out another public purpose so as to come close to the very purpose that has been envisaged or envisioned by the founder. Therefore, this is an instance of Cyprus doctrine. And sometimes this is a case where purpose is fulfilled, and in another case, it cannot be fulfilled at all, or it cannot be carried out according to the direction given in the instrument creating the trust. And all in those cases also, the purpose can be altered. And next is where the original purpose of the trust provides a use for a part only of the property available by virtue of the trust. Suppose if the property has been dedicated to the purpose of the trust, but with a restriction, only a particular part or only a limited part of that property can alone be utilized. Though such of those directions will cause hurdle in the administration of the trust or in realizing the purpose of the trust, then the court will always find out a way. It will clear the way for the use of the entire property along with other property which is meant for the purpose of the trust. And also, if the fund or the property of the trust can be better utilized than the purpose for which it has been created, and also if it is a public cause and also public purpose, and it also very close to the spirit of the trust for which it is created. In those circumstances also, the court will alter the purpose. Then original purpose. Likewise, if the disposal of the property or the usage of the property or the funds is not possible according to the direction, the court will always secure the funds of the trust, property of the trust, but find a way for using it for a public purpose in keeping with the main spirit of the trust. Therefore, this is a Cyprus doctrine. And this is all relating to public trust or public charities. Now, this also, as I have already said, only two persons can file the suit for settling a scheme or for rendering account by the trustee, for removal of trustee. Then only two persons and more can file the suit with the permission of the court. And Advocate General, if he wants to file it, then he can file straight away without the permission of the court. Then the case law on the subject is 2004-13 SEC, page 402. 2004-13 SEC 402. And the condition being, that is reiterated in that particular decision, it is a Supreme Court decision. First of all, there must be existence of a public trust. Second, allegation of breach of trust. It must invariably contain an allegation that by the existing trust, by the existing trustee, and the administration is not carried on in accordance with the deed of trust, or there is a breach of trust conditions contained in the trust. This should be the second allegation. And also, they must also plead the necessity of interference, necessity of a direction from the Honorable Court for better administration of the trust. Therefore, they must plead that in the circumstances of the case, unless the court intervenes and settles the dispute, there is no other go. Otherwise, the property or the trust will go into ruin. Therefore, these three conditions must be fulfilled. Only when these three conditions fulfilled, a suit of that nature regarding public charity or public trust can be filed. That decision I have already given. Then section 93. Section 93 speaks about who can file the suit. As I already said, in those two cases, section 91 and 90, 91 deals with the public nuisance and 92 deals with the public charity. In those two cases, now forget about the power of persons or the right of persons to approach the court with the permission of the court. Here, AG in both the cases come for the case dealing with public nuisance and also cases dealing with public charity can be filed by the AG without the permission of the court. He can always file it straight away. But in districts, there may not be any AG, Advocate General. Advocate General is based in Chennai or in the principal city of a state, principal headquarters of state. Therefore, his services may not be available. In such circumstances, the state government may appoint the district collectors of respective districts to file such a petition or to deal with matters that comes under section 91 and 92. But here one rider is that the district collector cannot delegate his power to any other subordinate. He can alone file a suit on behalf of in the place of the Advocate. But it is not as if the power of Advocate General to file suit anywhere in Tamil Nadu. If it is to be taken as the case to be filed in Tamil Nadu, the Advocate General has power to file suit anywhere in Tamil Nadu. Therefore, it is without prejudice to the power of Advocate General, the state government may nominate district collector or any other person, but the state government may nominate not only the district collector, but any other person to file a case under section 91 and 92. But once that power is conferred either on a district collector or any other person by the state government, they themselves cannot delegate their power to any other person. Therefore, only those persons who are authorized, district collector or any other person by the state government, can alone file the suit. This is with regard to section 93. Then section 94 deals with supplemental proceedings. Supplemental proceeding is nothing but the power of the court to pass interim orders. There are so many provisions in the CPC giving power to the civil court to deal with the situations as and when arise. And in accordance with the situation that they develop, the court has power to pass interim orders during the pendency of case. But apart from that provisions, one more provision is given. It is a superadded provision given under section 94. Under section 94 is giving a wide power. I can say it is even a wider power than the power conferred under Order 39, Rule 1 and 2, dealing with grant of interim injunction. And also section 151 also. 151 also, 151, section 151 of CPC, you may know that provides inherent power or confers inherent power on the civil court. Whenever the court finds that an order has to be passed and for which there is no other provision, but in the interest of justice and to do justice to the parties, if any order has to be passed, the court will pass an order under section 151, exercising its inherent power. Therefore, even that power, if it is not found adequate to meet the exigencies of the situation, then the court has been given a superadded power under section 94 of CPC under the caption supplemental powers. The supplemental powers is given only to see that yes, ends of justice from being defeated. If the court feels that if an order is not given, the ends of justice or the purpose of justice will be defeated. But this is a wide power. When I use that word, ends of justice means the court can do or court can pass any order that will further the ends of justice, that will facilitate the ends of justice. But if the ends of justice nothing but purpose of justice is defeated by the conduct of any of the parties, then the court has ample power to see that ends of justice is not defeated or ends of justice is protected. In those cases, circumstances, the civil court can always pass order, interim order under section 94. What are those powers? I will read it. The court may, if it is so prescribed, issue a warrant to arrest the defendant and bring him before court to show cause why he should not give security for his appearance. And if he fails to comply with any order for security, commit him to the civil prison. Here, this is a power given to the civil court to issue a warrant of arrest to a person who is not attending the court. That must be the reason. Here, these powers are not given under any provision of the CPC. Therefore, in order to plug that loophole also, now out of abundant caution, this power has been conferred on the civil courts. Because according to my knowledge and also during my career, I have never seen a civil court issuing a warrant of arrest for the appearance of a party, except when he commits some misconduct. Otherwise, the court will not, in a civil court will never call upon a party to appear. And also, if he doesn't appear, the court will issue warrant. It is not the practice. If a party is represented by a council, that is enough. And also, the advocates also take adjournments after adjournments. And therefore, this is a section, or this is a provision given to the civil court or a civil court only to see that the defendant appears. But if he doesn't appear, in spite of an order passed by the court, then the court has power. It is not as if the court is powerless. The court can secure his attendance by issuing a warrant of arrest. This is out of abundant caution, but which I don't think any court will exercise it. But there is power for issue a arrest of warrant. Then second, direct the defendant to furnish security to produce any property belonging to him and to place the same at the disposal of the court or order attachment of the property. Here also, in spite of the merit of the case, without reference to the merit of the case, a power has been given. A power has been conferred on the civil court. As if the court should not feel helpless when an exigency arises. Here, therefore, the court has power to direct a party to produce a property or to place a property at the disposal of the court, so that in case of a decree that can be utilized. Or for his appearance also, for any purpose. When a case is pending against a person, the court can call upon that person, you produce your property, or otherwise it will attach that property. Therefore, this is an ample power, a superfluous power given to the court. It is not as if there are no provisions in the CPC, but thinking that there may not be any provision to meet certain exigencies for securing the presence or securing the obedience of the party or a defendant. This abundant caution, this power has been given for a direction to the party to place the property at the disposal of the court. And in case he doesn't place it, it can always attach the property and sell it. And appoint a receiver. The court has a power. There is a provision under section 38, I think, order 38 deals with the appointment of receiver, I think so. That is I will come across that section when it comes. But anyway, there's a power conferred on the civil court to appoint a receiver also to protect the property during the pendency of the case, which is the subject matter of that case. Therefore, as if there is no power for a civil court to appoint a receiver, this appointment, the power of appointment has been given in section 23 1D, section 94 1D, and also make such other interlocutory orders as may appear to the court to be just and convenient. Here also it has been reiterated, and section 151 is there, providing or conferring inherent power on the civil court to deal with any contingencies during the course of the case. But here also, once over again, a power has been conferred on the court to deal with any exigency of a situation. Conferring, this is also an inherent power. That is, make such other interlocutory order as may appear to the court to be just and convenient. And an order of injunction can be granted. You know that a civil court has a power. When a suit is filed, any plaintiff will ask for an interim relief in the form of an interim injunction. This interim injunction is provided under order 39 rule 1 and 2 of CPC. Under order 39 1 and 2, any person can ask for that relief of interim injunction during the pendency. But there also certain parameters are given. Under certain circumstances allowed, you can ask for that relief. Therefore, you can say the power of a court to grant the power under that particular provision of law, Order 39, Rule 1 and 2, are restricted. It has to keep in mind certain inhibitions or restrictions, certain contingencies. Only those contingencies arise, or only those parameters are met. Then only the court can grant that order of injunction. Therefore, feeling that the lawmakers feeling that the civil court may be restricted or constricted in the grant of interim injunction whenever a situation arises, and the existing provision does not meet those situations. The court felt one more power, even if it is superadded, it has to be given or has to be conferred on the civil court. Therefore, with the result that the order of injunction, the order of temporary injunction can also be given. That power is also conferred on the civil court. Therefore, now you go through cases reported on this subject here. AAR 2004, Supreme Court 3992. AAR 2004, Supreme Court 3992. Therefore, one can say it is debatable also. This section 94 gives more power than the power that is conferred on section 39, rule 1 and 2, or even section 151 of CPC, which gives inherent power. Therefore, this is power given on a civil court out of abundant caution that the court should not feel helpless whenever a strange situation arises, wherein the court should not feel that the court is the hands of the courts are tied. Therefore, to break such inhibition, this power has been given. And only in order to render justice or to meet the ends of justice. And section, one more is, even maintenance, in maintenance case also, the court can order interim maintenance. That's a reported case under this section, section 94. Under section 94, interim maintenance also can be filed in a suit filed by the wife for maintenance under section 94. Yes, a petition has been filed under section 80, can be filed under section for maintenance under the Hindu Marriage Act by a Hindu woman. In those cases, section 94 also has been pressed into service and the orders of time under that section, providing for interim order or such as a relief as may be found fit by the court. That was taking advantage or exercising that wider power. This in a suit for maintenance, interim maintenance has been granted to a wife. That is reported in AAR 1973, Madras 369. This is a case on that particular topic. And also, as I already said, in circumstances which do not come under Order 39, Rule 1 and 2, this section can be pressed into service. You can also apply for relief under this section from a civil court. And it is an extraordinary power. You are invoking, I can say this is an extraordinary power because it is a superadded power. Power that has been already granted, but out of abundant caution, more power has been given. Therefore, it is an extraordinary power given to the court. But if you invoke that power in a suit and also get an order against the prejudice of another party, and if it is later on found to be malicious, then the court will award compensation. This is the only inhibition or restriction. Therefore, when you get an extraordinary remedy in a court of law, requesting the court to exercise that power under that extraordinary provision, then in case later on it is found that you have misused your right to invoke the jurisdiction of the court under that particular provision, then you will be mulcted with cost and also compensation suffered by the other party. And also the compensation can be given not only for the injury caused, but also any damage or injury done to the reputation. Therefore, this is you can always file a petition if you are wronged by the passing of order, that extraordinary order under section 94. And here also, this order can be obtained for compensation in the very same suit after the decree is passed. But in the decree, the order for compensation will not form a part. It is a collateral proceeding arising out of the decree granted in the suit filed under section 94. Therefore, the order for compensation is a separate proceeding or it is a collateral proceeding, a side proceeding. In that proceedings, you can obtain an order by filing a separate petition in the very same suit, but it will not form a part of a decree, but it is an interlocutory decree. Therefore, it will, if an appeal is filed, no appeal can be filed against the order passed in this collateral proceedings. It will not form part of the decree. The case on hand is 1961 2 MLJ 454. And these are all with regard to this particular section. Then comes appeals, first appeal. A first appeal can be filed against a decree passed by a trial court. Section 96 speaks of the appeal. That is nothing but a first appeal. A first appeal can be filed to the court to which an appeal is provided under our CPC. This trial court's decree can be challenged in the appeal to an appellate court. And this appeal can be filed only by an aggrieved person. aggrieved person. Who is that aggrieved person? This aggrieved person is none other than, as a result of a decree passed in favor of the plaintiff, the defendant will be the aggrieved person. And if the suit is dismissed, the plaintiff will be the aggrieved person. In those cases, either the plaintiff, if suit is dismissed, can appeal, or if the suit is a decree, the defendant can file an appeal. This is the called first appeal. And the power of the court while dealing with the first appeal is, it can go into the facts of the case. And you can, I have already, I think I have touched upon this topic. This is a continuation of the suit. The first appeal is also a continuation of the suit, treated as continuation of the suit. Therefore, the first appellate court can go into the merits, not only with regard to the facts, but also the question of law. Therefore, you can even say the first appellate court is the only court which can review the finding of the trial court on facts. Therefore, it is a final court of appeal with regard to facts, or a final court of appeal on facts. There is no other court. Even in second appeal, you cannot raise any question on the question of facts. If it is already decided by the first appellate court, that is the end of the matter. With regard to facts, there ends the matter. You cannot raise the question of fact in higher courts, in whatever form it is filed. Therefore, first appellate court should be a responsible court. It is supposed to be responsible or very vigilant. Therefore, it has to go minutely into the facts already dealt with by the trial court on the basis of the evidence. And also, it can go into the question of law also. But law, you leave aside sometime now. But with regard to the facts, it is a final court of appeal. Therefore, first appellate court is expected to deal with the facts as if it is a trial court, dealing with all the evidence on record. Therefore, the first appellate court should be careful. And then is this aggrieved person. Suppose if a preliminary decree is passed, and the preliminary decree is passed, then you have to file a preliminary decree. Suppose, for example, a suit for partition. In a suit for partition, the final decree will be preceded by a preliminary decree. In the preliminary decree, the court will find who are all eligible for a share, and what extent of share each and every owner is having. Therefore, it will ascertain, and also it will decide some question of fact and also question of law. In those cases, the person who is aggrieved by such a fine has to file an appeal under section 96. If they don't file an appeal against the preliminary finding, then when a final decree is passed, they cannot take the points, or they cannot question the findings rendered in the preliminary appeal in the appeal filed against the decree, the final decree. Therefore, out of abundant caution, if any party to the partition suit or any other such like suit is aggrieved, then necessarily they have to file an appeal. That is called first appeal. Then with this, I like to close the lecture today, and we will continue the lecture on the next day.